Hi, everybody.
Hi.
Good afternoon.
Good afternoon. I hear a dog.
Afternoon. Not
Good
me.
afternoon. Huh?
It wasn't
Not
me.
you?
No.
Okay, I'm receiving some of the midterm. Not all, just a few so far. Okay, I'm about to send you some, I think about 3 questions, and then we will start. Wait for a few more people.
Miss
I was-
Archer, quick question.
Go ahead.
I just wanted to know with the midterm, is there like a specific time you want these, or is it just you need these today?
Today. No time.
Today.
Yeah.
Okay, good.
No time.
So,
No time. I have received 4, I think. You had a chance to read the chapter for today? I guess. No.
I ain't sleep yet, Miss Archer. Oh,
So
partially.
when did you start the midterm?
I started on Tuesday.
Ah,
What I did was I compiled my stuff. And then when I started writing, I realized I wasn't making any sense. So forgive me if I have answers the team all over the place.
but you all
Yeah,
had almost 2 weeks.
I know, but my work, man, and things get in the way. Life got in my way this
Oh,
last.
okay.
So
All right.
if you start reading and it don't make sense, just remember I said I didn't sleep. That's all.
Okay. I got you. Anybody else have explanations to give?
I mean, I'm pretty sure we could all agree that life would have gotten in the way. But that's about it.
Hold on. Before you continue, what does that mean?
I mean, any sort of unexpected, things
Oh,
happening,
okay.
coming up.
Okay,
And
I
then
got it.
from my perspective, one of these questions was out of the way since we didn't really go over this chapter. So I
Which
tried
one are
my
they?
best. Hang on.
Which one are those?
Hang on. I got it.
Because I don't have it in front of me.
4B. This is the one with,
Crazy one.
with the shareholders changing the articles and share with the shares and such with the competing rival or what may be a competing rival in the company.
Okay.
I remember reading a case along those lines, but I couldn't remember which case it was. So I didn't reference the case, but I'm pretty sure it was similar circumstances with that particular question. I just can't
From
remember
chapter one.
which case it was.
Was this one of the cases in chapter one?
I think so, yeah.
Mhm.
That's why we didn't. Not everybody did all of the cases.
No, it was referenced in the reading.
In the reading. Mhm.
Yeah,
In the
it wasn't
reading.
the one,
What reading?
the thing, the unit.
Which
If you
unit?
read Unit 1. So if you read Unit 1, Ms. Archer referenced some cases in there as the explanations of each section would have been going on.
You're breaking up.
Yeah, it got break. Yeah, the internet is acting funny.
You're
Mhm.
breaking
Yeah.
up. I don't know what's going there. Is she still connected?
You know what I mean?
Yeah, but she's still going in and out though.
Okay, I'll type it.
Okay.
Hey, Blair, your sounds can. Okay, I don't know what just happened, but Blair were talking and it went in and out, and then
It
my
shut off. Like,
yeah.
she said she's typing.
Oh, okay.
I don't know. You can see it? Because I'm on my phone. On my phone, I don't see any typing. So you'll have to read what she says for me. Finish this question. Oh, where was I? Where was I? Where was I writing this from right here? Yeah. She's typing it?
Okay, there it is.
Okay, what did she say?
One of the cases was referenced in Unit 1, but I'm not sure it was among the list of cases at the back of the unit. Yes, that's where I was saying that not everyone went through that full list. So I don't know what she would be referencing to in that.
But I thought she said she was typing it.
Only what I read off was what she had typed.
Oh, okay.
Hello, everybody.
Hello. So why you thought it went to the chapter we haven't covered as yet?
Because that chapter was about shares. So I started
No,
trying
but
to
that ain't
read
the
that
question, though.
anything.
No, the question isn't asking you about shares. Read that question again.
About change, the question was asking in regards to altering its articles.
Okay, all right. So the question was on the Articles of Association. I haven't read any. If you want to change your answer, you have time.
Yeah, that's why I asked when you needed these for specifically.
Oh,
So
okay.
you'll get that.
Okay.
You'll get that today because of this issue.
Okay, all right.
We have until what time?
No time, just send them in today.
Okay, okay,
No, I didn't put no time.
okay.
And for the time. Hold on, I was writing the last one and I'm gonna send you some questions. So I hope you had a chance to read the chapter for the day. And yes. And somewhat, yeah, that's fine. If you glance at it,
Yeah.
you may be able to answer my questions I'm about to send. Extraordinary resolution. Where's everybody today? It's not a holiday. It's not a holiday. I mean, there is another one coming up, but still. Company law one. Okay, I sent it. You're gonna take a stab at those, or you want us to start the chapter first? Anyone willing to start? The difference between preference and ordinary shares?
I think the preference shares, do you have first rights, I would think.
Yes, they have first rights.
Hmm.
Okay, y'all could think about the answers. And whoever's the first one, okay, you got a part of it, but it's a little bit more. Let's start on this topic of shares, shareholders, and capitalization. So everybody should know what a share is. It's really an interest. A share can be an equity, and it can also be a debt. A share is a property, and it is subject to the articles of association. It can be sold, or it can actually be given as a gift. Shareholders have various rights, and that depends on the type of shares that they have acquired. So there are different rights attached to different types of shares. And you normally find the articles govern the shares, purchase and sales. So what are the general rights that attach to shares? The first one is you have the right to attend general meetings and vote. So shares carry one vote, may carry one vote at a general meeting, but shares can also be non-voting, or shares can have multiple votes. The second characteristic about a share and its rights is you have a right to a share in the company's profits, and that means dividends. The third is you have the right to the final distribution on the winding up or the liquidation of a company. So once all the creditors are paid, the remaining assets are available for distribution and division among the shareholders, either by a return of the capital or a distribution of surplus capital. And the fourth thing is the company, the rights that attach to shares is that the company must be run lawfully. So only members of a company have the legal right to sue to make the company act lawfully with some restrictions. Any questions there for the rights that attach to shares when you are a shareholder? You can attend the meetings. You're entitled to a share in the profits. You're entitled under the final distribution and winding up or dissolution or liquidation. And of course, you have a right to make sure that the company is run lawfully. So like I just said, there are different types of shares. A company can confer different rights on different classes of shares. And the main types being preference and ordinary shares. So let's look at ordinary shares. They normally carry one vote. They are normally entitled to participate equally in dividends. And if the company is wound up, to share in the proceeds of the company after the debts have been paid. There could be different classes of ordinary shares, such as a class A, B, C, D, and that allow directors to pay different dividends. Or they could have different exercise of control or different rules. And then there may be different ordinary shares with different nominal value. So not all shares can be, say, at a par value of $1. They could be at 50 cents, 10 cents, 20 cents. Preference shares are normally preferential in terms of dividend. They have a right to a fixed amount of dividend. And that's normally expressed as a percentage of the nominal or par value of the share. So a $1 share with a 6% preference means that you get 60 cents dividend each year. Preference shares, they have no voting. And they're sometimes redeemable. And the thing about preference shares is they have priority either by the articles or by the terms of the issue. And they are entitled to the repayment of their capital in full before the ordinary shareholders. If there is surplus left after the discharge of the company's liabilities and the repayment of capital to all shareholders, the surplus is divided among the ordinary and the preference shareholders, unless the articles provide something to the contrary. So where the articles give preference shareholders priority of repayment of capital in the winding up, but do not refer to any further rights in the capital of the company, the preference shareholders have no right to participate in surplus capital. And the last thing about preference shares is they're often not entitled to share in the surplus capital, like I just said. So let's go to my question. Question 3. You want to try that one? Where rights
These
are
are the
attached
questions
to-
you sent today, right?
Yeah, just now.
Okay.
Just a few minutes ago. Is 3 too hard? You're gonna wait until we reach variation? Do 2 instead then. Where would a preference shareholder go to ascertain the rights attached to their shares?
Say the articles of association only. Because it maps out all the conditions. I think.
You think?
Yes, ma'am.
Okay, anybody else?
I think the articles.
Just the articles? That's 2, nobody else? Just the articles?
Yeah, the articles.
I think.
Huh? You all absolutely sure?
Hang on, hang on.
You're not? I hear somebody saying I'm not.
No, I'm saying hang on. I'm trying to read.
Oh, okay, let me wait for you then. I'll wait.
Yeah, the articles. It wouldn't be in the M&A.
It wouldn't be what?
Wouldn't be in the memorandum. Or at least I don't think it would be.
I think it's D.
No, it's not. It's
I think
D.
D. Yeah,
It's D.
yeah, it right in the
For the
front, it right in,
articles and terms of issue.
yeah, it
Mhm.
right in. Mhm.
You see it in your notes too, right?
Yes, indeed.
Oh,
Wait a minute.
I think I should put some of these on the final exam. You see how you all just went for the one answer, which we know it is the Articles of Association.
Mhm.
But remember, when it comes to preference shares, you can also do it by the terms of the issue. That's why they have so many different types of preference shares and different types of ordinary shares. Because sometimes it depends on the terms of the issue. So the answer is D. Okay, don't kick yourself now. It gets easier as we go along. Okay, so the disadvantages of an ordinary share. So we know one of the disadvantages is that the ordinary shareholder is entitled to a dividend only after the preference shares have been paid. Where the preference shares have preference as the capital, the ordinary shares rank behind the preference shares for repayment of capital on winding up, or where there is a reduction of capital by repayment. The preference shares must be fully repaid first. So that is why they normally say that the ordinary shareholders, they hold the equity capital of the company. The advantages is the voting power. So that means that in general meetings, they allow them to control the resolution of the meetings. The voting rights of preference shareholders are adequate if they can vote when their dividend is in arrear, on resolution for reducing share capital and winding up, and on resolution which are likely to affect their class rights. Another advantage of ordinary shares is that their dividends are not fixed and they may increase substantially with the profitability of the company. Another advantage is that the company may issue bonus shares for which the shareholders does not pay in cash, or they can make new issues or rights issues at a lower price than old. And so both of these are generally offered to the existing ordinary shareholders. The general principle is that the rights enjoyed by one particular class should not be varied by the holders of another class of shares within the company. So that means that you have to gain the consent of the members of the class whose rights are subject to the proposed variation. And you'll see that when we look at the section in the Companies Act, section 37. Non-voting shares, they carry no rights to attend general meetings or to vote. They're sometimes used, issued to employees as remuneration to be paid as dividends. And the preference shares are often non-voting shares. You also have redeemable shares. These are shares issued on terms that the company will or may buy them back at some future date. The date and terms may be fixed. And the shares are redeemable at any time at the company's option. Preference shares are normally redeemable. A company article of association normally stipulates the terms and conditions for the issuance of redeemable shares. Then you also have deferred ordinary shares. These are shares which no dividends is paid until other classes of shares have received a maximum dividend. You have management shares, and these carry extra voting rights so as to retain control of the company in certain shareholders' hands. And normally with management shares, additionally, they are used to allow original owners of a company to retain control after additional shares have been issued. So you may have instances where you have three classes of shares. You have voting shares, dividend shares, capital shares. The M&A may have provisions in it, and it gives protection to holders of a class of shares against the rights on their shares being altered. For example, minority class of shares or class of non-voting shares would not be vulnerable to the rights attached to those shares being altered by the majority. And this is called the variation of class rights. So, nominal value of shares. A company may have shares of nominal or par value or no par value. Anyone can tell me the difference between a nominal, par value, and no par value of a share?
Nominal, would that be any amount you fix, or like $1 or 40 cents or something like that? I don't know.
Yeah.
And, no par value is what it says, no par value. Zero.
So what's par value?
Par value, I don't know if it's the same as nominal.
Yes, it is.
Yeah, okay.
Par value, nominal value, face value is all the same thing.
Mm.
And all they really refer to is the amount at which a security is issued or the amount that it can be redeemed by. That's what it means. So the significance of having a company limited by shares and have a nominal value on its shares is that the measure of a shareholder's liability to contribute towards the payment of a company's debt is the nominal value of the shares he holds, unless he has agreed to some additional sum. Once a shareholder has paid to the company a sum equal to the nominal value of the shares, plus any agreed premium, he has discharged his obligation to contribute. So who could tell me what's a participating preferred stock? You know, they have all kinds of different shares. Participating
Yeah.
preferred.
Yeah.
So participating preferred, it gives the holder the right to receive dividend equal to what's paid for the preferred dividends to preferred shareholders. And plus they get any additional dividend based on some predetermined condition. So now you see why some people prefer to get the preference shares.
Mhm.
Because their investment is not considered as equity because it's not stable. Yes, they were paid first and the ordinary are paid second, but they sometimes have conditions attached to it. So capital. The share capital is the amount contributed by the shareholders to the company's resources. And the money or assets which are contributed becomes the company's property immediately. However, the company does not become the shareholders' debtors for its repayment or restoration. Everybody understands that because that is key. So when you form a company and you have established capital, some shareholders are of the view that the monies that they have placed in capital to start the company, that the actual company owes that to them. But it's not the way a company works.
Mhm.
Once they have invested that money in the company, that becomes the property of the company. It's no longer theirs. And the company does not become a debtor to the shareholder. The only thing that they're entitled to after they have established and paid their capital is what?
Repeat that again?
After the shareholder has contributed their capital to the company, what are they entitled to?
Share certificate?
If you was starting a company now and you say you're going to start it off with a capital of $5,000,
Yeah,
what are you entitled to after that? Once you paid in your 5,000?
the share certificate?
Yeah, but more than that, more than your share certificate, you're entitled to the base of dividends,
Oh, yeah, okay.
right? So that's why you have to understand the concept in common law that once you have invested, that the only thing you're really entitled to is dividends. That's it. And the company doesn't owe you anything. So because you invested in the company $5,000, that doesn't mean that the company owes you $5,000.
Mhm.
So as a result of the contribution, the shareholders has a number of statutory and contractual rights against the company. That's all they have, statutory and contractual rights. And among which are one, the right to share or to a share in its residual assets when it is wound up, to receive dividends when there is a profit in accordance with the Articles of Association. And these are the only two rights that give the shareholder the value and make the shares saleable. A share in the residual assets and dividends when there is a profit, according to the Articles of Association. So there are different types of capital. You have nominal capital, issued capital, paid up capital, called up capital, and unpaid capital. So nominal capital, that's the nominal value of the shares that the company issues. And this is the figure that appears in the capital clause of the memorandum. A company cannot issue shares beyond its nominal capital. And there is no minimal nominal capital for a limited company. So now you have nominal capital. Out of that nominal capital, you can have issued capital. And this is the total of the nominal value of the shares which have been allotted to shareholders. The difference between nominal and issued is what you call the unissued capital. So you could have nominal capital, issued capital, unissued capital, and you can also have paid up capital. That's the total amount that's being paid by the shareholders on the shares that they have taken. And of course, you could have unpaid capital, that the company has not received payment of amounts from its shareholders equal to the nominal value of the shares issued to them. So a company can say, we're going to have a nominal capital of $10,000 or 10,000 shares. Then it's going to issue those shares out. Let's say it issues it out to two persons, 5,000 each. But out of that 5,000 for each shareholder, they've only paid 2,000. So they have unpaid capital. And they have paid capital. And then you could have called up capital, and that's paid up capital plus the unpaid up capital, which the company has called on its members to pay. So for the example I just gave you, they would call on those two shareholders to pay the balance of the shares that they owe. So each one would owe $2,500 to the company. The real value of shares is the amount that a person is willing to pay for a share. And this normally is based on what's in the stock exchange. And that tells you, based on the current price, whether someone would be interested in buying or purchasing the shares of the company. Nominal value, go ahead.
Just a question. With the initial investment, does that have to be given right away, or can that be on a payment plan? How does that work? I don't know. I may have missed it. How does it work with the investing the money?
Okay, if you start, okay, if you, let's say you want to purchase 1,000 shares. Now this is for a business now.
Okay,
This is not like you're purchasing shares, like bonds. That's different.
okay,
This is if you are starting a company and they say
Uh-huh.
that their capital is $10,000. That's what they're gonna start with. And
Mhm.
they say they're gonna sell their shares at $1 per share. And you
Okay.
said that you want to purchase 1,000 shares. So that's your nominal value. But you only have $500 in cash,
Mhm.
right? So
Right.
you would still, the company would still have unpaid capital of $500 from you,
Okay.
right?
Okay.
Now there are different ways in which you could pay for your shares.
Okay.
It doesn't have to be in cash.
Okay.
Yeah, doesn't have to be in cash. You could be the person who is giving the property
Uh-huh.
and that
Okay.
has a value on it, or the building that has a value on it, or you could be bringing in a certain amount of clientele, and you could actually draft your contractual agreement whereby it is equivalent to the shares that you're getting.
Okay. So
Right.
does the articles have to take into account all of that?
Yes.
Okay.
Yes. Uh-huh.
Okay.
Yeah. So those are the things that you have to think about in terms of when you form in a company and you're gonna have to get investors. What type of arrangement are you willing to make? Because
Okay.
everything will not be in cash.
Okay.
Okay.
I got it. Okay. Thank you.
All right. So nominal versus real value of shares. The nominal and paid up values of shares normally serve as a measure of the shareholder's liability to contribute towards the repayment of the company's debts and also calculating dividend payments. The nominal value provides no measure of the real value of the shares. Because remember, the real value of the shares is the price that someone who wants to invest in the company is willing to pay. Company law is not primarily concerned with the real value of shares. They're normally concerned with the nominal value of shares, especially when it comes to reduction, alteration, and variation of class rights. You're looking at the nominal value. Payment of shares. A shareholder must pay the nominal value or greater value price of his shares to the company in cash, where shares are allotted by a company without any different method of payment. A company may also allot shares which are credited as paid up to an agreed amount for consideration other than cash, like we just discussed on your question. So whether shares are issued for payment in cash or for consideration other than cash, they cannot be issued at a discount. The allotee or any subsequent holder of shares are liable to pay the company in the amount of the discount in cash if the shares are issued at a discount. So normally when shares are issued, they agree to pay their nominal value or higher price by legal tender or by check or negotiable instrument. But it has to be based on, the consideration has to be something that the company can sue or bring a claim against. Shares are also allotted for cash when the company is indebted to the shareholder and they agree that the debt will be discharged by crediting the shares paid up by the equivalent amount. A shareholder may be held to have paid for his shares in cash by the agreed cancellation of a debt owing to him, such as a vendor of property. He sold property to the company. And so they would actually cancel it out as cash. And it'd be a compensation. A creditor may also agree with the company that his debt shall be paid by crediting the shares of another person as paid up by an equal sum. So remember in our last class, the case that we read, The Bahamian case?
Yeah.
With staff,
Okay.
yeah.
Yes. So now you see what he did in his contract. He gave the loan, and in lieu of them not being able to pay, he converted it to equity. A transfer of property to the company may also be consideration for the allotment of shares other than cash. An allotment of shares may also be made for any other valuable consideration, such as the license to use a patent or a trademark. So a contract may be made for the allotment of shares for consideration of cash or consideration other than cash, and may indicate the number of shares to be allotted and consideration provided.
Can you give an example of that?
For the, a contract, it's just,
yeah.
okay, if you use the one from the case with Sabas,
Uh-huh.
they would have entered, they had a loan agreement.
Okay.
That's their contract.
Mm-hmm.
And
Okay.
in that contract, it says that if they are unable to pay, if they default,
Mm-hmm.
then they will get equity in the exchange
their pocket.
business, right? Underneath that same loan agreement, they have another agreement that when the borrower defaults, then there is a contract that states that they now have the right to convert that mortgage into an equity
Okay.
and purchase the shares. So they don't have to give cash.
Mm.
And
Okay.
then, and you remember what it said in the mortgage deed? The mortgage deed actually stated how much shares they would be allotted.
Mm. Okay.
But that's how businesses run. Let's say if you were to give that loan and you don't have anything attached to it, which means that if they don't pay, then you go through the process of taking them to court, demanding that they pay, working out a proposal or a plan for them to pay, or you have to wait for them to sell the business. The best way to do it is you just take the asset.
Okay.
Yeah, that's how you do. That's how a shrewd businessman would operate. Think about it.
Okay.
No,
Yeah.
think about it. If you and I were to go into business, okay, let's say I'm going into a business, a clothing business,
Mm-hmm.
and I want to start a company, right? And
Yeah.
I say, okay, I need to start off, I need about $50,000. I only have about 15. And you say, okay, I could lend you the rest,
Right.
right? So you can say you could lend it to me, and in your contract, you could say in the event I default,
I
we
taking
can
your
go.
business.
No. First you say, no, you learn that after Sabas. But you'll say, we'll go to arbitration or something and work it out and
Okay.
right, okay. And then you probably put in there that presently I have whatever is collateral. Maybe I have an antique car you could use or something. Let's say you put they'll be for sale. But a shrewd businessman, he's gonna take that opportunity. I'm investing in this business because I believe that this business can make it.
Right.
So if you cannot pay, I will take the company from you.
Mm.
That's what a shrewd businessman will do.
Yeah. Okay.
So
Understood.
that's how business works.
Yeah.
So that's why a lot of times when you see businesses change hands, people be wondering why, and they go, "Oh, I'm so sorry for him. How they just take over the man property just like that?" There are clauses in those agreements. If I invest my money in your company, and your company is beginning to fail, and you cannot pay, let me take it over.
True. Okay.
Yeah,
Thank you.
you're most welcome. Get to make the thing real, It
Yeah.
ain't just on paper. That's
Yeah,
how you
yeah,
company
makes
door
sense.
close and it open again.
Mm.
Whoever they borrow from, everybody don't borrow from one of the clearing banks.
That's true.
people borrow from how they call themselves. They call
Money
themselves
lending.
no, don't say money lending. They call themselves conglomerates.
Okay.
So there'll be 4 or 5 businessmen who are willing to lend people money
Yes. Yeah.
to start up their business. And when you cannot pay, they will take it over.
Mhm. And you get left with nothing.
Obviously, you can't pay. You can't pay. It could be worded in a way whereby they will give you a minority share. Or it could be worded in a way whereby I'll say, in the event that I'm unable to pay, and clause so and so takes effect, which means that the borrower now becomes the owner. I
Right.
could ask, I could put in that contract to remain maybe the purchasing manager or the
Mhm.
operating manager. You can put all of that in the contract. That's how
Okay.
you sell the package. You tell them what you want. In the event I'm unable to do this for whatever reason, I still want to stay here.
Okay. So you still get some payments, some form of payment?
No, you'll get salary then.
Okay.
You become a salary because they'll take over.
Okay.
And if they want to do it the way Sabas owned was, Sabas would not have been the majority. They would have still owned the majority.
Mhm.
But they could have forced their hand at a meeting to sell them more shares, especially if the company is failing. That means that they don't have what it takes to turn the business into a success. So what you have to do is get rid of the people who are running the company.
Okay. That explains good.
Yeah, that's how it works. But always remember now, from when we started from the very first class, this is what the Solomon principle is all about. It's not about me and it's not about you. It's about the company itself.
True.
Company and the shareholders. Next class, we're gonna look at the directors. Okay, so the share certificate. Everybody know that's issued by the company, and it certifies that on the date of the certificate is issued, a certain person is the registered owner of shares. And so the certificate itself is prima facie evidence of the member's title to those shares. And normally people just issue one certificate in respect of the shares issued or transferred at a particular time. But a shareholder may request for their share certificates to be split. So say he bought 5,000 shares, he may say he wants 2,500, a certificate number 001, and then another 25 for certificate 002. But normally it's just one certificate that is issued. So a company will be prevented from denying statements in a share certificate against a person or entity that has relied on that statement. You understand what that means?
Not really. Denying a statement.
Yeah. So let's say someone is holding a share certificate. In their name is dated and is stamped. A company cannot say that those shares do not belong to that person.
Oh.
And especially if he's relied on it, that you have already done everything to make that transfer or the acquisition effectual. You have, once that is issued, you are a member.
Right. Mhm.
So for transfer of shares, we know that's duly executed and there's a transfer form. If you look in table A gives you an example of what a transfer form looks like in table A. But on the reverse of the certificate is where you have that printed. And then you stipulate the name of the company, the name and address of the person that the shares may be transferred, the name and address of the person who currently holds the shares, that's the transferor, the number and the value of the shares, the signatures of both the transferor and the transferee, their witnesses, and then the company secretary. And let me ask you a question. When does a transfer of shares become effective?
I think when they entered on the register.
Yes.
So-
when it's recorded in the register. Remember that. So let's see, parties to the transfer, we've done that already. We know to transfer on the transferee. And let me go back to my question. Did I miss a question that you could have done now? Yeah, can you do number 3?
Let's see.
Is it D?
That sounds like that's a guess. You have to sound confident. Hold on. I type in another question. Number 3, where the rights are attached to a class of shares set on the company statement of capital. No other answers? You said D, right?
Yeah, I said D.
Okay. Anybody else?
I think it'd be by the members. Let's see.
I didn't hear you. What'd you say?
Is it C?
Okay, you just stick the answer because we're about to do variation now. I just want C.
Oh, okay.
What did you say? You say D, she say C. Anybody else?
My computer froze and my internet is doing something different, so I can't even see the question.
Oh, yeah, right.
I can say
Rights
all of the
attached to
above.
a class of shares set out in the company's statement of capital and initial shareholdings, and the company's constitution and the articles do not contain any provisions regarding the way in which the rights may be varied. Then they may be varied by
Hold your answer. We're about to do it right now. Answer that one for me. I just send you another one. We'll come back to 3. We'll come back to that one. By the time my internet should be up. You're getting away from me.
I should have Cable Bahamas. I don't have no faith in Cable Bahamas.
I have Cable Bahamas too. Don't forget, sometimes I go down and come back. I can wait on you. I just sent a new question.
Okay, I got it.
Okay, what's the
A?
answer for that one? Huh?
I say A.
I hear A.
I say A. Because you're already in a meeting.
Okay, anybody?
Oh, sorry, hold on. What type of residence was that? General meeting. Anything other than, if you're going to do other businesses extraordinary,
Mm-hmm.
I think it's D.
Who say B?
I think it's D.
Who said A? You said A first?
I did say it and I say, hold on.
Oh,
And I read it again.
anybody else? I need to put some of these on the final exam. Nobody else?
Okay, I'd say either A or D.
But now you know you can't come with two. But you could hold your two in your head. But it can't be
Fine, then
two.
I'll confidently say D, but I'm still between A and D.
But how you gonna be between A and D? They're two different things. How you get A and D? Okay, hold on. I'm about to send you all another one. See if y'all get more A and D and C and A and hold on. Anybody else?
Yeah, I'm going with D on this one.
Okay.
Seeing that it's calling for an increase, something special.
So it should be an extraordinary resolution.
Yeah, that's what my gut feeling is saying.
Okay. Anybody else? I have two D's, one D and A.
I'll leave it at just D then, Miss Harcho.
Oh, you're a D. Because everybody else doing D.
No, because I start off saying D, but I was still between both of them.
Okay. The holders. Okay, I'm doing another one for variation. And y'all could tell me not less than 15%. Okay, spelling mistake will be okay. Giving you all another one. Less than 21 days. Okay, so let me ask this question now. According to the Act, Companies Act, Section 37, if you wanted to vary the rights or vary the class of certain shareholders, what is required by law?
What you said, Ms. Archer? What?
If you wanted to vary the rights of a certain class of shares, what are the steps you have to do?
I guess prepare a resolution per se. Or this in your article?
No, you gotta go read Section 37 of the Act. I have it in your notes, so you don't have to go look it up.
Provision is made by the memorandum or article authorizing the variation.
The first thing is what? If you want to vary the rights, what's the first thing you need? Don't you need consent?
Make provisions.
Yes, you would need consent
You need consent.
from the other members or shareholders.
And then what happens after that?
Resolution.
I think you need a percentage.
Resolution passed at a separate meeting.
Yeah.
Anybody holding more than 15%. That's what this first part is saying.
to the court.
Okay. About to send you one that does deals with variation. And then we will go through the act. See what it says. Okay. I sent it. What's your answer?
15%.
Remember you were saying there's a percentage?
Not less than 15%.
Mm-hmm.
Let's see. A.
Yes, anybody else? You say A, anybody else? Blair, what's your answer?
So initially I was thinking it was A, no, sorry, C.
C, okay. But now you change it to
But
what?
no, I didn't change it. I just saying the day is a little off. I'm seeing 15 days in here. Oh, sorry. No. It's 21 days.
So what's your answer? What's your answer? Mills, what's your answer?
I'm torn between A or C. Well, actually A or maybe D. I don't know. I'm all over the place.
You're killing me.
Right there. Right there.
Okay.
A seems more
Read-
accurate, but
Read section 2.
Huh?
Yeah, because I'm
Hold on.
trying to find it fast in my reading, but my eyes ain't finding it fast. Percentage. I'm looking
Okay, all
for the
right.
percentage.
All right. Section 37 says that if you want to vary the rights of any class, first thing you need, it cannot be done without the consent of a specified proportion. And that specified proportion is 15%. The holders of not less in the aggregate than 15% of the issued shares of that class. That's in subsection 1 of section 37. And then it says they have to apply to the court. And the application has to be made within 21 days from the date the consent was given or the resolution was passed. So the answer is A.
Yay.
I was close.
So it got to go to the court, and the court will hear what the applicant has to say, whether or not the variation is unfair, and it would prejudice the shareholders. And the decision of the court on any such application is final. And what the court does, the court makes an order. And the company has within 15 days from the date of the making of the order by the court,
21.
15. How you get 21? It's 21 to get the application in.
Oh, sorry. Okay.
15 days for the order.
Oh, you saying order? Okay.
Yeah, it's an order by the court.
Oh, yeah, I see it now.
Uh-huh.
5.
And a copy is sent to the registrar. If the shares of a company are divided into different classes, ordinary and preferences, the expression class rights refers to the special rights of a particular class of shareholder concerning dividends and voting and rights on a winding up. The act makes it clear that abrogation of class rights is included. That means that a class rights can be extinguished entirely as well as merely varied, provided the appropriate procedure of the section set out above are followed. So the act actually allows you to vary it and abrogate, which means to get rid of a whole class, cancel it completely. So unless this is so, consent of the particular class of shareholders is not required. In the case of Adelaide Electric versus Prudential Assurance, the court held that the alteration of the place of payment of a preferential dividend did not vary the rights of the preference shareholders, despite the fact that the exchange rate acted in favor of the company and against the preference shareholders. So the methods of variation or abrogation. The act states that the variation of the rights attached to a class of shares may only be varied, A, if the provision is made in the articles of association to vary it, or where the company's articles contain no such provision, if the holders of the shares of that class consent to the variation. And consent is required under the section. 1, any specified proportion of the holders of the issue shares, that's the 15%, and the sanction of a resolution passed at a separate meeting of the holders of those shares. So consequently, a resolution to vary the rights of a particular class is of no legal effect unless the consent of the class is obtained. It should be noted that any vote on a resolution to modify class rights must be undertaken for the purpose of benefiting the class as a whole. And the case for that was the British. Go ahead.
Is that why they sometimes issue you'll see a resolution and then you'll see something. It's not common to accompany a resolution, but you'll see where they say so and so has agreed to or adopted this resolution or something. I can't remember the exact wording, but a particular director will say that they agreed to whatever was passed in the resolution.
A particular,
maybe director or shareholder or someone. I can't remember exactly the word.
It got to be a shareholder, it can't be a director.
Okay.
Because you're varying the rights of a class of shares, so it has to be a member, a shareholder.
But I mean in general, not really specifically related to the shares or changing thing, but sometimes they'll issue a resolution and then I'll see where someone else who's a member or officer of the company say, I agree to this or something like that. Like I said, it's not common, but I've seen it sometimes.
It depends on what the matter is. If there's something that takes a motion, yeah. So that means that someone has to second the motion.
Okay.
Yeah, some secretaries don't put the motion was passed by so-and-so. They don't always put that in the minutes.
Okay.
But there are certain, when you make a decision, you'll hear the chairman will say, and I table this matter, and then someone say, I agree. And he said, can I have a second? But normally in the minutes, you don't see all of that written.
Okay.
Okay, so let's go back to the other question what I asked you. What type of resolution is required at a general meeting to increase the nominal capital? What type of resolution?
A.
A?
Yeah.
Okay. Everybody agreed?
Yes, I'm going
Yeah.
with ordinary as opposed to D.
Mm-hmm.
Because you're already at the meeting.
Yeah.
Yeah. Okay. So y'all getting good at this.
No, brother. Not on my side.
You're barely struggling along.
I see multiple
Oh.
choice. I shut down. Completely.
What does that mean?
I don't like multiple choice. I prefer short answer and as I
Yeah.
go.
I can leave my last multiple choice for the exam. Yeah, the finals. Final exam.
When we having the final, do we have to take a day off or anything?
Why? What for?
I don't
I
know
don't
when it's
think
going to
so.
be held. Oh, okay.
Yes,
how
in
it's being-
class. It's in class. Yeah, you may need the day off. Yeah.
Oh,
Yeah,
okay.
yeah. You may need the day off.
It's true. I mean, it's through the week.
No, it'll normally be on the same day on a Saturday.
Oh, okay, okay.
On a Saturday. Not
You
through
know
the week.
the date yet, right?
Yes, the date is set. August the 28th.
Oh, okay. No, Jesus. All right.
What you was thinking?
I was so lost just now. I still in zombie land. Don't mind me.
You need to come back in this land.
I gotta sleep first, Miss Arthur.
I don't know why y'all take so long to do this midterm. Y'all had plenty time.
That's my fault. I know. I can do better. I mean, we don't have any more assignments, but still, I can try
No.
not to do myself anymore.
Oh,
Blair, have you finished your capstone? That is still pending.
Not at all. Not at all.
pending. You should be finished.
Not at all.
Oh, no.
The capstone?
Nowhere
Yeah.
near.
No, ma'am. It is a no.
Mm-mm.
I don't know what happened in my crew this time. You're supposed to be eager beavers. I'm trying to find something I can ask you all to see if you understand. Alteration of capital. I'll find something. I put it on the final exam. Alteration of share capital. So it can be done if it's authorized by the articles, by a resolution of the shareholders. So alteration means that you can increase your share capital by creating new shares. You can consolidate and divide all of your shares in the share capital, or you can convert all or any of the paid up shares into stock and reconvert that stock into paid up shares of any denomination. You could subdivide your shares, and you could fix it by the memorandum so that the subdivisions and the proportions between the amount paid and the amount, if any, unpaid on each reduced share, or you could cancel shares. So cancellation of shares under this section should not be a reduction of share capital within the meaning of the act. A company's share capital may be altered or increased, provided the company follows the appropriate methods and procedures. Alteration may increase the nominal share capital, redivide the company shares into shares of a greater or smaller nominal value, or the classification or reclassification of the company's share capital. A limited company having a share capital may not alter its share capital. except as set out in the section 49 to alter it. That is, it is authorized by its articles of association. A limited company may make certain alterations to the provisions of its memorandum of association with regard to share capital by passing a resolution at a general meeting. Unless the memo or the arts state otherwise, the resolution may be an ordinary resolution. So now you see where your answer came from?
Yes.
Okay, very good. A limited company may consolidate its capital by amalgamating shares of smaller amounts into shares of larger amounts. Then, of course, like I said, you could subdivide and make them more marketable. Instead of having a big block of shares, and you can divide it so you can get more subscribers. Now, to reduce your shares, that's section 50 of the Companies Act. A company limited by shares and a company limited by guarantee and having a share capital, if they are authorized by their articles, by a resolution, or the shareholders reduce the share capital in any way, and without prejudice to the generality of the foregoing power, they may extinguish or reduce the liability on any of the shares in respect of share capital not paid up, either with or without extinguishing or reducing liability, cancel and paid up shares, which is lost or unrepresented by available assets, or with or without extinguishing or reducing liability, they can pay off any paid up share capital, which is in excess of the wants of the company. And then they could alter its memorandum by reducing the amount of the share capital and its shares accordingly. A limited company may reduce its share capital by special resolution confirmed by the court, or a private company limited by shares by special resolution supported by a solvency statement. An application is made to the court for confirming order, any objections by creditors and settlement of objecting creditors. If the court is satisfied with respect to every creditor of the company who is entitled to object to the reduction, that either his consent to the reduction has been obtained, or his debt or claim has been discharged or has been determined or has been secured, the court will issue an order confirming reduction. The court may direct that the company add an inverted commas and reduce end quotes on its name until the expiration of the period of the time specified in the order and is a part of the name of the company. The court may also order the company to publish the reasons for the reduction in capital or some other information to the public. Then, of course, just like when you would have done an abrogation, you have to register the reduction of the share capital, and the company is required to register with the registrar a copy, then a minute approved by the court showing with respect to the share capital as altered by the order, and you would give the amount of the share capital, the number of shares into which it is divided, the registration of the order and the minute. The notice of the registration is published in the manner as the court directs. The registrar certifies the registration of the order and the minute, and his certificate shall constitute conclusive evidence that all the requirements of the act has been complied to for the reduction of the capital. Once registered, the minute is substituted for the corresponding part of the memorandum, and it is valid and alterable as it has been originally contained in the memorandum. The substitution is deemed to be an alteration of the memorandum within the meaning of section 29. So the liabilities of shareholders is in section 54. Subject to claims by creditors, a shareholder of the company, past or present, is not to be liable in respect of any shares to any call or contribution exceeding the amount, the difference, if any, between the amount of the shares fixed by the minute and the amount paid, or the reduced amount, if any, which is to be deemed to have been paid on the share, as the case may be. There are also redeemable shares, and that's normally done to encourage investment in the equity of small businesses. And sometimes you have family members, they would normally buy redeemable shares. So the issue of redeemable shares is at the option of the company or the shareholder. The articles of a private limited company may either exclude or restrict the issue or the issue of redeemable shares. But a public limited company may only issue redeemable shares if authorized by its articles. Redeemable shares may be issued only if there are in issue other shares which are not redeemable. If all the company shares are redeemable, then this would circumvent the perpetual succession feature of a company. Redeemable shares may not be redeemed unless they are fully paid. The issued capital is the creditor's buffer, and this is the figure and not the paid-up capital which must be replaced. Redeemable shares may only be redeemed out of distributable profits, out of the proceeds of a fresh issue of shares made for that purpose. Any premium or redemption must be paid out of distributable profits of the company unless the shares being redeemed were issued at a premium. Under section 55, a notice must be sent to the registrar for any changes in the share capital within 30 days of the share consolidation, division, conversion, subdivision, purchase, or otherwise acquired or canceled or stock reconverted. Acquisition of own shares, that's section 44 of the Act. The Company Act provides that a limited company having a share capital may purchase its own shares subject to the provisions set out in the Act. And it says, subject to its memorandum, a company may purchase its own shares. However, it may not make any payment to purchase or otherwise acquire shares issued by it if there are reasonable grounds for believing that A, the company is unable or would, after that payment, be unable to pay its liabilities. Or B, the realizable value of the company's asset would, after that payment, be less than the aggregate of the liabilities and issued share capital of all classes. A purchase or acquisition of shares under section 44 shall not be a reduction of share capital within the meaning of the Act. A company may purchase its own shares for the following reasons. A private company may purchase its own shares because it gives their shares some marketability. In a family company, the shareholders may not agree how many shares each should take if there is a death of a shareholder or resignation or retirement, and they would prefer for the company to purchase the shares rather than inviting an outsider to become a shareholder. Third, if there is shareholder dispute, a compromise can be reached buying out the shares, again avoiding the introduction of an outsider into the company. And fourth, it is also useful when an executive director who has taken shares decides to leave, the company can buy his shares so that he severs his ties with the company. So what happens if a shareholder dies? What happens to their shares?
It goes to the estate of the person.
It goes to the estate. So if he dies intestate, that's without a will. Of course, you have to wait for the letters of administration and then follow the wishes. If he died testate, that means with a will, you have a grant of probate, and normally the executor can actually begin right away upon death to effect the changes. So, and they can do the transfer of the shares and a new share certificate is issued. So now let me find you a question for alteration. Okay. All right, it's coming. This one won't take long. It's not a multiple choice.
That's not fair.
Of course it is. I'm thinking of putting an actual balance sheet on the final exam.
Oh, goodness.
Lord Jesus, help us, Lord.
I said thinking.
Let us forget, Jesus. Let us forget.
Come on, y'all good for that.
How much hours
Yeah.
this test can be?
Huh?
How much hours is the final exam?
Final exam, 3 hours. Yeah, see that? Too much time. No, I won't give you a balance sheet, but I might.
Miss Archer, you
Okay.
sent the question? Oh, okay.
It's about to send right now. 2 spelling mistakes. 2 spelling mistakes I'm correcting, but other than that, I think you could read it. Okay, it's gone. Boy, silence. Multiple choice, you all eager beavers.
You gotta read first, Natasha.
Okay. No, me all read aloud.
These questions long, Natasha.
Oh, come on, 4 sentences.
We should do a resolution first then.
That's the first thing to do.
Special resolution confirmed by the court. Hold on.
You have to start with consent in this as well, Ms. Archer.
What you doing though?
To reduce the share capital.
Uh-huh. And so,
Uh,
what's your steps? I heard resolution.
Resolution to reduce the share capital.
Mm-hmm.
Supported by a solvency statement.
Yeah, if it's a private company.
And then you make an application to the court.
Uh-huh.
The court is satisfied.
You may have some objections by creditors. That's under section 51.
Okay.
I thought you should start, how come you don't start off with consent in this before you go to the court to make the application? I'm a little confused.
Section 51. Hold on, where's my book? Because it's not written like how the one for variation abrogation.
Mm-mm.
It's written differently.
Yeah.
You could read 51. You have 51 in front of you. Hold on, let me get my book.
51.
Because I try not to put too many sections in the notes. I'll be there in a minute. 51.
Wait,
I understand your question, but let me see what the act says. But it speaks to creditors. So the creditors go by notice. Yeah. It's for the creditors. This objection by creditors is after any claim by any creditors after the date that's fixed by the court. So you would actually put in the application to the court, then the court will give the creditors a certain number of days to bring a claim.
Okay.
Yeah. Remember now, when you're doing a variation abrogation, that's against the shareholders' class rights. So you have to get that consent. But this is the reduction of share capital. Reduction of share capital, as you know, then that relates to creditors and the liabilities.
Okay.
So once you put the order into the court, then the court gives the creditors a certain number of days to bring in a claim.
Okay.
So the question says, you're required to write a report for the finance director explaining the methods which may be adopted to reduce the capital of the company. So what y'all gave me just now is the process. They ask you for the methods.
See, this where the words get tricky with these ethics.
I just know you're coming with that word tricky.
Tricky, Ms. Archer. Okay.
No, it's not tricky. It asks the methods.
Yeah.
What's the method?
So we weren't on the right track.
Affirmed by court or a resolution supported by a solvency statement?
That's a method? No,
I
that's a
think
process. No,
extinguish or reduce the liability, is that?
Yes, that's the method. There are
Mm,
3 methods. That's the 3 methods they're looking for.
Okay,
So if you look at the first one, if you extinguish or reduce the liability, that would not be in favor of the creditors.
okay,
okay.
And if you look at the third one, that would also not be good for creditors.
Mhm.
What about B? Cancel any paid up share which is lost or unrepresented or by available unavailable assets. So the second one, B, the B more or less brings the company's, let me see, bring the capital in line. Cause see what it's doing? It says that it cancel any paid up share capital which is lost or unrepresented by available assets. So you're really not touching the core part of the capital. You just bringing the legal capital in line with your net asset position. And so it doesn't really impact creditors. And that was the easy one, right? You could have answered that by saying section 50.
Yeah.
okay. You sure
Fine,
that's
well,
all section 50?
Yeah.
that's the
That'll
section
be
50.
wonderful. Go to section 50.
No, you don't just right go to section 50 now. It's a little bit more than just go to section 50. You have to explain. Let me see. If I could find anything, I could think of anything else that would be easy. Let me see.
Ms. Audra, I had a problem kind of interpreting what was in the act. So even though I may have found the answer concerning the midterm, I mean,
Uh-huh.
even though I may have found the answer, breaking it down was a little difficult to kind of interpret what they were saying. So, do you have any advice on how to do that? To kind of make it make sense?
Like how to, okay, give me an example.
Okay, so,
Which question?
I can tell you. Right. Hold on, where the exam?
I'm trying to find my exam too. Okay, I have it. Which one?
Let me tell you. My computer's slow, so give me 1 second.
Okay, that's all right. I have mine.
Okay, so for part C of question 1,
Uh-huh.
where we were to advise Carmichael Formal Suits on the suggested choice of name. Similar to find in the act the different sections that referred to that, but summarizing it, because it could have been really long. But summarizing it without putting it there word for word was difficult. And I don't know if we were to actually quote the part of the act or just refer to it and then answer the question.
You could refer to it, and then put it in your own words.
Okay, because I ended up just kind of taking stuff out that I don't know if my answer really was that long, but the act itself, I ended up quoting a lot of the sections. So I
Okay,
don't know.
I'll look at it when I look at it, and I'll see if you could have just narrowed it down a little bit more.
Okay.
Yeah, because sometimes you don't have to write all of that. You can just put some dots in between, 3 dots, and just put the part that you want.
Right. Okay.
Yeah, you don't normally have to write the whole thing out. Okay, I'm about to send you another question. So everybody understood that one? Method
Yeah.
versus process.
Yeah. Now I do.
Yes.
And that happens sometimes because you all know the process so well from when we did abrogation and variation. You just pick right up on it and think that's what the question was asking you, but it wasn't. Give me 2 seconds. I'm sorry for those who are not in class today. All right, I sent it. So quiet.
Is that learned, but learns that the directors may object?
Okay, something wrong? Well, what I get errors from. Okay, Edward owns a small number of shares in 7 Limited, a private company. He wishes to transfer these shares to a charity, but fears, that's supposed to be F in front of that,
Okay.
but fears that the directors may object.
Okay.
And then my question is, for what reasons may the directors refuse to register such a transfer? And for how long may they delay their decision? Oh, come on. This one is a brain teaser.
Honestly, I don't even know where to look for this answer.
Okay.
Yeah, because I'm looking through the ZAC Fast and Furious and wondering if we should be looking in the actual company law stage 1 manual.
I have one idea. I have one idea, Miss Archer, but
Go ahead.
I'm not entirely sure. For where he's saying
ahead.
he's trying to transfer it to a charity. This is a private company. Can that even be done? Wouldn't that make it a public company? Or force it to become a public company that can issue shares outside of its members or such?
Yes, that's one point. Don't give up so easily. Let's go. Think. Think. Come on, y'all can do this. Don't. Everything is. You already have the framework for transfer of shares. Correct? You know, most things, you know that for internal matters, that's in the articles. So answer this is a practical question. And then I'm going to give you some case law to go with it. But I want you to think of it practically first, and then I'll tell you what the case law is. Put yourself in the shoes either as the charity or the company.
Would a
They don't
variation of
open up to the risk of becoming a public company? No risk. The risk involved, probably. That's one of the reasons.
That
Correct.
could be discussed. Think about it now. Okay, so let's look at the question. So Edward owns a small number of shares and he wishes to transfer these shares to a charity, but fears that the directors may object. For what reasons may they refuse to register such a transfer, and for how long may they, I guess, take to deliberate their decision and give him an answer? Everything turns on, I gave you all a clue, articles of association. So if in the articles itself, it speaks to equality of votes, then a transfer cannot be rejected. Think about it now, the articles determine the internal runnings of the company.
Mhm.
So unless the articles stipulate otherwise, that right of rejection apply only on a transfer by a member, and it do not arise on transmission through death or bankruptcy. And neither do they arise where the shares are still represented by a renounceable letter of allotment. So he wants to transfer his shares to a charity. In the case of Hackney Pavilion, Hackney Pavilion, Hackney Pavilion, the company had 3 directors. Each one of them had 3,333 shares. One of the directors died, having appointed his wife as his executor. Her attorneys wrote to the company enclosing a transfer of the shares from herself as executress to herself in an individual capacity. At the board meeting, the other 2 shareholders and the secretary were present. One of the shareholders proposed that the shares be registered, but the other one objected. He said, in accordance with the provision in the article, there was no casting vote. The secretary then wrote to the attorney informing them that the directors had declined to register the transfer. It was held that the board's right to decline required to be actively expressed. The mere failure to pass the proposed resolution for registration was not a formal active exercise of the right to decline. The right to the registration remain, and the register must be rectified. So if you actually going to decline, as this is a charity, and like you say, there's a risk involved, then you actually have to discuss it and state the reasons why it's being declined.
Okay.
And of course, you cannot take a long length of time. Okay, hold on. You know, I'd be trying to correct spellings mistakes. All right, send you the next one. Any answer?
Oh, you sent it?
Get it.
Okay.
You know, I have to keep your brain ticking, you know.
Yeah. I think it could be by app.
Any answers?
Um,
Oh, come on.
Is it B? I'm just guessing.
You guessing? What are you doing? This should not be here. What'd you say? B?
I said B. I just. it's just a
Okay, let me
guess.
see what anybody else, what the others have to say. That's a guess or that's a confirmed answer?
That's a guess.
That's a guess. Okay, let me wait on the others. Oh, come on.
I want to say, okay. I
What
want
is
to
this
say,
doing?
I want to say B too.
You can say B? Okay. Anybody else? My internet doing the same thing because I writing another one and it just going all jumping all over the place. I can read this one out because I can't get it to keep still. No other answer? No answer?
I'll go with B.
B?
Yeah.
You are correct.
Oh, great.
Hallelujah. Look at God.
Okay, I just sent one just now. Tell me if you got it because this machine doing its own thing.
I got it.
Yeah. I got it too.
Okay. Okay. Give me your answer.
Okay.
Oh, come on. See, just jumping all over the place.
I say B
You say B. Okay, who else?
because it has the provision.
It's in the articles, so.
Yeah.
I say B as well.
B?
Yeah.
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 Hmm. Why?
Because I'm saying it's already stated in the articles, so it'll be valid. It already provides for this transfer to be made or orally.
Right, yeah.
That's my take.
I mean, realistically, it shouldn't, but like it's stated, if it's in the articles, that's what they should be abiding by.
Mhm.
So if you go to the schedule at the back of the Companies Act, tell me what does it say about shares and transfer?
Okay.
Where are we exactly?
Hmm? In the schedule.
Forfeiture of shares, version of shares, share warrants.
What does it say?
Shares.
This is the first schedule we're talking about.
Yeah. Mm-hmm.
Okay.
Firstly, remember from when we started today, when we spoke about shares, what are shares really? In layman's term, what are shares?
Like money and
Isn't it not a personal property?
Mhm.
Yes.
Okay. And how do personal property pass?
Share, share transfer,
By gift or
Okay.
sale.
give,
So can they put in articles to transfer shares in that method? Would that be legally correct?
You mean by transferring it for gift or sale?
No, he's transferring it orally
orally.
under company law. Can that be done? Don't forget now, that's why you see a lot of people when they incorporate a company, they use a template instead of trying to change things.
Mhm.
By company law, can you transfer shares orally?
No.
Because by company law, a company cannot transfer shares unless they have a proper instrument of transfer. Isn't that what it says in the schedule?
Yeah.
You gotta have a transfer instrument and it has
Okay.
to be duly stamped and it
Mhm.
also has to be delivered
And
Signed,
sign.
sealed, delivered.
and executed.
Mhm.
Yes. Okay then. So answer the question.
Okay, so it would be A then.
It's A.
Mhm.
But if they have a provision that says it can be done, and can't they just do the transfer form afterwards? Or is
In
that basic?
company law don't work that way.
I mean, we just basically said that's what happened with the other thing where the person said one thing before the contract was done and then wrote something else later, or wrote whatever it was later.
What you talk about pre-incorporation?
No, was it acquisition? When we were talking about the island luck thing again,
Uh-huh.
They did a contract. Or?
That's a contract.
yeah, but the M&As are basically a contract, right?
That's between the member and the company. He's transferring his shares to someone else. And this transfer says in articles that it can be done orally. How can you affect that transfer orally? That's just like me say I'm holding 1,000 shares and I come to you and say, I transfer my 1,000 shares to you and I walk away. And then you walk and you see Blair and you tell Blair, okay, I'm transferring my, where is it? To effect the transfer of shares, there's steps that have to be taken. It's just like you buying a piece of property. It cannot be done orally. So by putting that inside, actually putting it in it, does not make it legal. It's just like you saying you're going to sell marijuana, you have a contract. That doesn't make it legal. The act itself is not legal. You understand now?
Yeah, yeah.
Okay. I'm sending you another one. I should have saved that one for the final exam.
You could put it on there too.
No, don't try it, don't try it.
You could put it a different way.
I can see you all in the exam scratching your head and can't wait to get aside to give me a piece of your mind.
So can we use the act in the exam?
No. Why would you need to do that? You know this by heart now. Just by the chapters, you know the sections you need to know. And if you've read this, at least take the time to read the Schedule A you know that the schedule refer to certain sections. And
Mhm.
especially when you're talking about shares and share transfer and rights, that's like the heart of the stage, this part of the course. And then when we do directors, you need to see what directors are responsible for in their fiduciary duty.
Okay, so it's just gonna be on 6 to 10, that's it, not 1 to 5.
Not necessarily, no. But you won't have no pre-incorporation questions.
Okay.
No. You may have something on Solomon because you know Solomon runs through everything. So, but there's no particular question on Solomon by itself.
Mhm.
Okay, give me the answer to that one.
What did we say the answer was for the bankrupt question? I don't remember what it was. Do you guys remember?
B.
B.
Oh,
B.
okay. Yeah, thank
She
you.
she'll put that on a paper so she see it again. She knows. Yeah,
You
I
might-
got you. I got you. I got you.
Okay, you might just change the names and I say, this look familiar. And
Mm,
that's good enough for me.
don't bet on that. Don't bet on that. No, don't bet on that at all.
Um, I'd say B.
You say B.
Uh-huh.
Okay. Anybody else?
Hold on.
Hold on. You taking back your answer?
No, I looking at the deed. This deed get me mixed up.
Okay.
In a stock transfer form. I think it's C.
You change it again to what? C?
Mhm.
Okay. Let me wait on the others.
I missed something here.
What'd you miss? Who changing the mind again?
No.
Listen here. I don't want to see no final exam with no holes in the paper, you know. Because I seeing holes now.
I'll stick with C.
You sticking with C. Okay, I'll wait on the others. I think the questions sometimes help.
Mhm.
Know what answers? What happened?
Hang on, hang on.
What happened?
Give us a second, Miss Archer.
Oh,
This one-
oh. I thought you all had fallen asleep. No, I'm not rushing you.
Like I and say E, I don't know. I have
E, you
no
say
idea.
E? Where you say E?
Right in my head. I don't know. I have
E.
no idea.
Come on, man, think harder.
Okay, give me 1 more minute.
Is it B?
B,
Yeah.
B as in boy?
Yeah.
No, why would he be signing a form in form of a deed?
Oh, sorry, hang on. The way the space next to each other. Sorry, I meant to say become a member and sign a transfer deed.
You sure?
But he's already a member.
Already a member, yeah. That's
Barry
so-
or George? Because Barry is the deceased and he's passing it to George, and there's no saying that George is a member.
What?
What? How you get there? No, you
I
didn't read
know.
that again.
Yes.
Okay, now I'm confused.
No,
Let's
no,
say
read
what
that
must-
again. Read that again. Read that again.
Barry dies and leave all his shares in Tow Ltd to George. Under the
Yes.
articles, the shares in Tow Ltd can only be transferred by the directors. What must Barry's executor do to pass the shares to George?
Uh-huh.
Okay, so from me reading it, I don't know where George stands in all of this.
George is the executor.
I mean, I get that.
The shares. Inherits the shares because of the
Yes,
will.
shares. Right.
I
And
should
he-
leave this
he
one for the
said-
finals too.
His name.
You can put it on too.
I should have left this one for the finals too.
Listen, no, I just been growing another gray hair, Ms. Archer. You can't leave these kind of questions. No.
Okay, so Barry is dead, and now his executor has the responsibility to have the shares transferred to George. And you're telling me that I should, which one you selected? A? What
Should
does
say
that
B.
mean? What does that mean, become a member? What does that mean?
He already a member.
No, 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 no. he's
George
not
is already a
member.
member.
Not a shareholder.
No,
No.
no. Barry dies, right?
Mhm.
And a part of his assets is his shares in the company Tow Limited. So he writes in his will that he wants the shares in Tow Limited to be transferred to George. The question is asking you, what steps or what is the next step for the executor to do in order to pass those shares to George?
Let's see.
Oh, you just have to sign the
Yeah.
thing.
See,
Transfer.
he just had to see.
Sign,
Exactly, the answer is C.
Mhm.
Oh, I was getting,
Yeah.
see, that's why you read Bahamas. I thought
Uh-huh.
George was the executor. That's what happened.
Right,
I
because if
thought
you
that
do,
was
right,
getting
because
lost.
if you selected A, then you're gonna make the executor a member.
Right, yeah.
Yeah, that was my confusion there.
And if the shares are not paid for, then an executor will become liable for payment of those shares. So no, you just have to sign a stock transfer form.
Yes.
That's why you're supposed to read. That was that's why I was saying I don't know. Does it
Okay,
sound
next
like-
question. Next question was sent already.
Oh, Lord.
got a their statement, you know, that when I was, you know, when my situation was going nowhere and I was in the bottom and I didn't have any idea how to do it or how to escape from my situation and stay on top.
Yes, Eager Beavers.
Knowing that I'm gonna pay for the everything like this or friends that know me way different than right now, you know?
Very structure.
Yeah.
Not being put in the register. I don't know. Let's see.
Yeah. Yes, I am. Maybe I mean, 37 has got a stick for a lot of us, people. But there's different things to do, you know, like
Worded.
doing this, you know, like I might do something else that they want that bad. You don't do that stuff or nothing, you know. You're normal things that like I want you know, and you know, different things and you know, there
Is
is
this to do with the share certificate?
What? That question?
Yeah, no?
No.
Okay, okay. The statutory restriction, but that's to do with
See, but you see why there's going to be a lot of questions on this section A.
Someone have a TV on or something? 'Cause
I hear it.
It's competing with the crowd.
can't hear you.
Okay, it's gone now. Was that Miguel? You think it's Miguel?
He muted.
Yeah, he's muted though, yeah. We're all muted. I don't know.
No. You can conversate for, you can conversate and see if they have found I say a different, houses, different places, different, friends or friends.
Does this have to do with payment of dividends?
No.
Oh, okay. Just making sure I in the wrong direction. Okay, thank you.
I'm not saying anything because last time you all told me give you a time to read. So I'm giving you time to read.
Residual asset. Dividends. This is the rights to share in the residual assets.
No. Breathing for what? It's all of this breathing hard business.
Ms. Archie, does it refer to redeemable shares, maybe?
You talking about this given the kind of statutory restrictions?
Yes, listen, is it along those lines?
No.
No, all right. I'm reading.
Okay. I will allow you to read.
Yeah. I don't, it's- I got a sense to do it when we go back to work. I mean, promotion or wages, you know, so that, you know, energy, a lot of the things, anything, whatever, and then just, you know, yeah, that's it. You know, I understood stuff like that, but I mean, well, wages, I would do that, you know.
Should I guide you all?
Yeah.
There was a hesitation there, you know. Okay, let me guide you. Remember when I said that when you purchase shares, some people do not purchase in cash. Sometimes people may have the property that the business is on and they're giving it in lieu of. Okay,
Yeah.
that's where that question is from.
Mhm.
Payment of shares. The
Mm.
section that speaks to payment of shares. How can shares be paid for?
It's cash or
Okay. Transfer property.
property transfer.
Right. A company may be indebted to a shareholder. There could be in a contract for consideration, like Sabas.
Right.
Yes, that's what that question is about. For this is talking about considerations other than cash. I could give you some cases, but I prefer if you're just able to say the various ways in which you can pay for shares.
Shares.
Yeah,
Okay.
I won't burden you down with the cases,
Okay.
but I at least want you to be able to figure out what it is that they're talking about. If I gave you an exam question, I say a company cannot issue shares at a discount. Discuss that. What will you say?
I'll say that's not true. I mean, that is
What?
true. No, that's not true.
No, it's not.
What?
Not true.
They can't issue shares at a discount?
No. Because the act says so. I don't know which part of the act, but somewhere in there. It says you can't buy law.
For consideration of an agreed value.
Now that's the question that could come on the final exam in some form. In some form.
Is that anywhere in the act or no? Only what you have stated here?
What I have stated there.
Okay.
Let me see if I can get you a case.
What? What the hell?
That's my neighbors. Hold on.
You live in Beantown, eh?
No, that's my dog. My dog don't like them. And so my dog barking at them. And she gazing at the dog, saying the dog could bite her. And the yard is fenced in.
Oh,
Wow.
Lord.
These people.
Mm.
Well, that's better than my yard. We had the police in the yard last night. Well, 2 nights ago. There was a domestic dispute.
Wow.
I was choking a lady.
Issued some convertible debentures.
Mm.
I give you that one. Let me see. if I
No,
can- Okay. You want me to type it? Is it better if I type it?
yeah.
Okay. Okay. Let me type it quick. Tau or Tow Limited, anyone. Issued. A. Hold on. E. Oh no, hold on. Sometimes I type so fast, I be typing on top of things. It's void, almost finished. It's almost finished. Void. It's void, and what else should I say? I put ballot, not valid. Excuse my typing. See. You all ready to come back to the classroom yet?
Yes.
See. You are a. If. Oh no, hold on. Two last words. If. So. No more questions after this. You'll be happy to know. Sam. Answers.
Is it C?
Okay, C, the issue is void, and so therefore it's the right to convert to shares. Mm. Mm.
Let me look again.
At least you love an idea how the multiple choice will come.
Yes.
This is now issuing shares at a discount.
I'll probably go with A this time.
Change to what? A?
Yeah.
Okay, let's wait on the rest.
I say C.
You say C.
Wait, hold on. Uh,
Why you always send one letter and then say, hold on and change it to another letter?
and because I tell you, Mrs. Archer, I stress out today. Okay, C. I stick it with C. I could be wrong.
Okay.
Stick it with C.
Why you say C?
Because you say you can't discount
What?
the share. Something you can discount. Hold on. I have it.
No other answers? I get one,
Shares cannot be issued at a discount.
I get an A and I get a C.
I say C. I stick it with C.
Okay. Nobody else have a different answer? I know you won't leave it blank in the exam, so.
Hold on. Is it D?
Will you get E? You know E there.
Oh, I say D.
Oh, D.
I'm not confident with that answer, but I'm going with it.
You're going with D.
Yeah.
Why?
I don't know how to explain that.
But you selected that one, so why you said that?
I selected it based on what I'm reading right now, but like
Okay,
I said,
so-
I wasn't confident for that answer.
Explain.
Where it says transfer property to company. I think, see, and even that, I don't feel sure on that.
Mm. Okay, so the first thing before you even answer this, very simple. Multiple choice question is, you have to know what is a convertible debenture. What is that?
It says there are corporate bonds that can be exchanged for common stock in the issuing company.
Mm-hmm. And they're normally unsecured.
Yeah, sorry.
They're unsecured. So they want to issue these convertible debentures at a discount. Can they do that?
It looks so, because they're getting. Let's see.
At a discount.
Pay the company the amount of the discount in cash.
Does the Companies Act allow you to issue at a discount?
No. It does.
Let's see.
So we're looking in the part 3 of the Companies Act.
Fine.
This part 3 with the incorporation.
No, part 3 of the Companies Act speak to share capital.
Oh, part 3, sorry.
Yeah, part 3.
Is it section, what is this?
That's 38. No.
35-4?
Where a company may issue fractions of a share.
Is that what we're talking about?
No, this is not fraction,
No.
this is the debenture.
Okay.
And they're issuing, and they want to convert it at a discount.
Paripasu, why does that sound familiar?
Sound familiar? Hey,
Very much so. Same rate or equal footing.
mm-hmm.
So no,
So what's the answer?
it's void.
Okay,
What would we read just now? 35 or 36? Which one?
36-2.
Oh. Rank pari passu. Okay.
Every morning the cows leave this enclosure. We can spend the night in. And then they go out.
that's the thing again, that's what somebody else say.
They go out
Hmm?
up towards the mountains. to go swimming.
That's like another class.
Or maybe a radio or something.
It was not us. Okay, so the answer is A.
You said the answer is A?
Yeah, A.
Scared?
Oh, I think I said A, right?
Just say it was void.
Yes, you did.
That's why
Huh?
the women are scared.
You know
No,
what?
you
Never
said
mind.
A and D. You said A and D, and then you say D. All right, that's the last question for the day. Let's finish the chapter. Y'all love multiple choice. I should give you the final exam of just multiple choice. Let us scream and say no. Okay, so nominee shareholders and beneficial ownership. I think you all know this very well, because there's an agency relationship between the nominee and the shareholder. So they hold the company shares in their name for the ultimate BO. So the nominee shareholder owes the same duties and responsibilities to the ultimate BO as an agent would owe to his principal. So the nominee, they have to perform their duties imposed on them by express or implied terms of the agency agreement. And the nominee agreement is between the nominee shareholder and the ultimate beneficial owner. And the nominee is expected to act within the limits of the agency nominee agreement and their actual authority. The principal can ratify any acts of the agent. And it's important that the provisions of the agreement between the ultimate BO and the nominee shareholder state clearly and comprehensively the nature and ambit of the nominee shareholder relationship, the duties and responsibilities of the nominee shareholder, and the extent of the authority of the nominee shareholder to act on behalf of the ultimate BO. So you know that this whole arrangement with nominee agency is a matter that the OECD is pushing to be eliminated completely.
Wow.
They don't want the ultimate BO to be behind a nominee shareholder. So that's why they asked for the register of beneficial owners, but they're still going to push for it.
Mhm.
They don't want that layer in between, because that layer to them is a layer of deceit. Now, they normally say that once you're in that nominee agency relationship, you have to perform stricter KYC. You have to really know your clients, and you actually have to have them risk rated based upon the nature of what they do and where they're doing business. So if you want to provide nominee services, of course, you know, you have to have a FCSP license, Financial Corporate Service Provider license. You could apply to the central bank for a restricted nominee trust license. And then you could act on behalf of certain clients. The minimum capital is $10,000. So normally they say, if you take a strict interpretation of the nominee shareholder agreement, legally, they say that it's a legal fiction, because the nominee shareholder has no real or practical liability. Any legal obligations or liability with regard to the shareholding remains the obligation of the actual BO, ultimate BO, and not that of the agent or the representative. And under the nominee shareholder agreement, because we did a question on this already, the shares of a deceased member of a company normally devolve on the personal representative of the deceased member. So on the death of the ultimate BO, subject to the provisions of the articles, the shares are held by a nominee shareholder on behalf of the ultimate BO, and they cannot be disposed of in any way that the company chooses, since the legal ownership of the shares is that of the personal representative of the ultimate BO. So shareholders' rights, they have, like I said before, both contractual and legal rights, and those are outlined in the memorandum and articles of association. And shareholders also have a certain statutory right under the Act. The general law may protect shareholders of private companies from fraud, illegality, or unfair prejudicial conduct of the company's affairs, but it cannot protect them from consequences of dissension within the company between the directors and its members, because it is not the function of the courts to review the merits of business decisions taken by the board of directors or the shareholders. So certain protection of shareholder rights are drafted in the Articles of Association. And that's in order to ensure legally and contractually the rights of shareholders are observed, protected, and maintained. So the relevant corporate documents and shareholder rights are the articles and the memorandum, the shareholder agreement, the nominee shareholder agreement, the declaration of trust, the register of members, the resolution of members, and of course, common law cases and the legislation, the Companies Act, or the IBC Act. So when it comes to the shareholders agreement, that is a contract between the shareholders of the company in which they agree how the company should be run. And the shareholders normally agree to use their voting powers in the company to ensure that the terms of the shareholder agreements are complied with. The shareholder agreement is designed to protect all parties to the agreement against the majority of shareholders. And they use their voting powers to the detriment of the other shareholders. Without a shareholders agreement, a company would normally be under the control of those who hold a majority of the votes and shareholders meetings. So there are some provisions that should usually be in a shareholders agreement. And those are they require the consent to be obtained from all or a specified majority of shareholders to appoint and remove directors, payment of salaries or fees to shareholders, and extend company loans, outline which management decisions may be made by the directors and which ones must be referred. They also have under the shareholders agreement acceptable company borrowing limits, the approval process for directors obtaining consent to be involved in a project, or circumstances in which the shareholders may approve contracts, hiring practices, or the commencement of legal proceedings. Directors and shareholders have two completely different roles. And you have to make a distinction between the two. Directors and shareholders, you have to determine who owns and who manages the company. So you know the shareholders / members, they own the company. The directors manage the company. Some decisions will be made by the directors, but only with the shareholders' consent. And some are made by the directors alone. So normally the articles of association normally specify the requisite number of shareholders and directors, which issues regarding the company may be made by shareholders or directors, what meetings may be called and organized by shareholders and directors, how shareholders may vote and participate in certain meetings, and what powers do shareholders and directors have. The relationship between the shareholders and directors is a complex one. The directors are subject to general fiduciary duty to always act in the company's best interest, not the shareholders' best interest, but the company's best interest. They are required to account to the shareholders for the preservation and profitability of the company, of the assets of the company. So even though the directors are responsible for the daily operation of the company and they make certain decisions which may affect the company, the shareholders of the company normally have the ultimate source of power, as they have certain powers to appoint and remove directors or give their consent for major decisions. Now the section there on dividend is just a summary. What I want to send to you now is a copy of a shareholders agreement, if it will come up soon. Okay, I have it. 1, 2. Okay, I sent 2 shareholders agreement. One is the US and one is a local one. So the first one is a US, where you see the company is called Pocotech. Everybody has it?
Just received.
Okay, all right. So let's look at the clauses in this one. The first thing they have is the transfer restriction of shares. It's the US one. They give you the general rules. They give you the permitted transfers. They give you the right of first refusal, non-cash consideration for shares, the right to transfer, and the right of co-sale, prohibited transfers, buy, sell events. Then they went on and discussed the preemptive rights. And they excluded transactions. Then they talk about the sale of the company in the event that they have to sell the company. Then they have the usual representation and warranties, limitations on compensation, use of proceeds and stock incentive plan, endorsements and share certificate, transfers, termination, just the regular clauses that are normally within a contract. So the main ones are the transfer of shares and the preemptive rights, and if the company has to be sold. Now look at the other one I sent you. Let's go. This one here is a PDF on shareholders agreement and what should be in it. I have another one to send you. And it gives a good snapshot as to the different types and what should be included. So you could read that. Plenty reading, eh?
Yes.
Oh, someone said yes. Okay, hold on. I have another shareholders agreement to give you. Well, at least you don't have to memorize the shareholders agreement. You're just reading it. Where is it? I have one for BTC. Where did it go? This may be it right here. Open that one, see if that's BTC. Hold on, it's spinning, it's spinning. Go faster. Yeah, this must be BTC, it's taking long. I found a shareholders agreement for BTC. Okay, sending it now. Then I allow you all to go and you should have it. Let me see if that is what it is. Yes, that's it. You have it?
Yes.
Okay, so this is the shareholders agreement relating to BTC. And let's look at this, have a quick look at the table of contents to see what they cover in their shareholders agreement. Capital and further financed as paragraph 4, directors and management, shareholder meeting, corporate governance, undertaking and reserve powers, matters, financial matters, dividend policy, non-competition, the Haiti cable link, regulatory matters, the guarantee, the disposal of assets, pensions, transfer of shares, the listing, and then from 21 is just the normal clauses you would put in a contract. So if you've never read it, you could read the shareholders agreement. 104 pages. You will be reading that one, right? I don't see why not.
Along with my morning coffee.
Yes, wonderful. I want to read, I supposed to have read the Haiti link.
Yeah,
Because
that
I
sound
never heard about
interesting.
it. Yeah, I'd never heard about that one before. They'd have it in here. And then CWC, what they undertake to do. It's a good document to read. The first one I gave you is a typical one. They only focus on certain areas. Normally it's about share transfer. the sale of the company and who they allow to have shares. Okay, they have the non-competition. So the Haiti Cable Link says they acknowledge BTC's investment in the BDSNI cable link between the Bahamas and Haiti, and agree that CWC shall procure that BTC should seek to maximize its opportunities to commercialize its investments in that cable link on a competitive basis. That's all it says. One sentence. That's it. All right, so now I'm going to wait for the rest of my midterm. I don't know if I'll have them ready for next Saturday at this rate. I'll see.
But you will get them today.
Yeah, but a lot of people are not online. You think they skip class in order to finish the exam?
Are you sure they even got it?
Mercy? Yes,
Well,
they had to.
They had to. Everybody's on it. If you didn't get it, you know you had class, you would have sent me an email or asked someone else in class. Come on now.
Yeah.
Yeah, there's no excuse. No excuse whatsoever.
I know, Ms. Asher, coming off topic, do you think there's
Go ahead.
going to be an early election?
Early?
Yeah.
I don't think it'll be early. I think it'll be on time. No,
Man,
what I mean is normally done in May, right?
yeah.
And we are ready. I supposed to say we're in August now.
Mhm.
And all the prime minister is saying, check your card,
Get
make sure
ready.
you're still there, make sure you're ready. But I don't
Mhm.
see him calling that between now and December.
Okay.
Not in the middle of COVID. That won't work.
No, okay.
I think what he may be hoping, I don't know about the opposition, but he may be hoping that by January, we are all back to normal.
Mm.
Because you know when it's politics time, everybody and everybody face.
Yes.
Right. So we'll never get the vote because everybody will be dropping down dead.
Yeah.
So
And
I
we
think that's
don't,
what
yeah,
Go ahead.
we don't have to re-register because once we have the last voter's card, we
Yeah,
don't have to
you,
go. on.
no, only if you no longer live in that constituency.
Right, okay.
Other than that, there's no need.
Okay.
So I would say once he has agreed that yes, we're opening up and we don't have a lot of cases because we don't know what's gonna happen when we open up completely. So all he's telling you is just be ready.
Okay.
And the criticisms are high. And so I guess if it opens and everything is looking good, he may say, okay, we haven't it. You got sufficient time.
Mm-hmm.
But it may be early next year. I don't see it happening so soon though.
Oh. Be ready.
But just be ready. I'm ready. My card is torn, but it's ready.
You sound like you're going to do some damage.
I had to use it for ID and the thing is so soft, it just disappeared.
Okay.
You know what y'all could do for me? I should bring this as a final exam question. But y'all could work on it if you want to. Tell me the difference between the memorandum and articles of association. Do that for homework. We'll talk about it next
That's too
class.
much.
Huh?
How was it in the hang on.
Yeah,
I
but
thought
you see
that wasn't the question or
That was one of the
in
questions.
the midterm.
I'm looking right now to see if I put that
At
there.
least that's how I answered one of my
made
questions
a
along
note.
those terms.
Which question y'all see that was?
I
It
thought
wasn't
Yeah,
really the
midterms, yeah.
difference, but
you mean 4A?
no,
Let me
I
see.
think that was 2.
That must be what they thinking for, hey.
Let me
Maybe
see.
4A.
Mm-mm. Mm-mm.
I want to know where you see that.
Mm-mm.
Yeah, 4A for me.
Yes, 4A.
Yeah, that's where I went.
Mhm. And yeah, they say they answered it in the midterm, so they don't need to do it. Wonderful by me.
You have some eager beavers after all.
Yes. All right. So next week we'll do directors, which should be quite interesting. It won't be as long as the one that shares. As you can see, a lot of questions will come from this chapter. So be prepared. All right.
Yes, ma'am.
So those who haven't finished may now send it. And I will speak to you all next week.
Right.
All right.
Okay.
Enjoy
Yeah.
the rest of your weekend.
You too.
Okay. All right.
All right,
Bye
good
bye.
afternoon, everyone.
Bye, everyone.
I'm sorry for those who missed class. We had fun.
We did.
Yes.
Yes, it
So I'm sorry for them. Okay. Enjoy your weekend.
You too, Sasha.
Talk to you later. Okay. All right. Bye bye.
Bye. Bye.
Okay. And